Hi, my name is Carolina Bernal. I'm a visiting researcher from Colombia. I'm here at the Human Rights Research and Education Center conducting a research about security policy and its relationship with discrimination. This is a short research, but I want to talk to you about a different topic today, that is the extrajudicial killings and military jurisdiction, because there is a big debate about that topic in Colombia at that moment. What I wanted to tell you is that the experience that I have in research has shown me that in those countries in which there is a big history of human rights violations conducted by the militaries, it is a big mistake that it is a big mistake that the army conduct the investigations of the crimes committed by the army. But unfortunately, that's what is happening right now in Colombia. So in the first place, I wanted to tell you about the problem that we have with body counting in Colombia some years ago, and then I will tell you the project of law that we are passing right now in Colombia that is very related to the problem with body counting. So this is the story. In 2006, the United Nations Special Rapporteur on Extrajudicial Summary and Arbitrary Executions, Philip Alston, along with some other Colombian state agencies, suggested that they have found that there could be some problems with the Colombian army because they found that the army had incurred in unlawful killings. It was commonly called in Colombia false positive. That is basically body counting. I don't know if you are familiar with this term, but basically it means it is a practice that has been implemented by the Colombian army and also by some other armies in different countries, in which civilians are killed and then dressed up in rebels' camouflage uniforms just to be counted as guerrillas killed in battle. In other words, to present their actions as a success in terms in the war. So it was the problem that we had, and it began in 2006, or at least there was the year in which we discovered that we had a big problem related to that phenomenon, because we have had this kind of body counting for many years, but only during the Uribe government, former President Álvaro Uribe, we had an increase on the number of body counting. Basically, the increase in the number of body counting happened in between 2003 and 2008. Uribe's government was from 2002 to 2008, so the periods match. Maybe the most famous case of extrajudicial execution was the case that we called Soacha, because it happened there. Soacha is a poor area near Bogota, in which like 23 young men were selected by the army, and they were offered two jobs, both in legal and illegal works, but they didn't work. They were killed, and the army presented their bodies as if they were rebels killed in battle. But it was very suspicious, their death, because for many reasons. The first reason was that their families denied that they could be part of the guerrillas, and also because their uniforms were new and their injuries were not like the injuries that someone could have is a skill in a battle. They had short distance shots, so it was very suspicious. To give you an idea of the extent of that phenomenon, because before the case of Soacha, we also had many other cases very similar. I will tell you that according to the official statistics presented by Todd Holland, the representative of the United Nations High Commissioner for Human Rights in Colombia, it was presented this year, there were 1,600 complaints filed for cases of extrajudicial executions. It means that it was a very serious phenomenon that we had in Colombia. And it showed that we had a problem with the army, mainly because of two reasons. The first reason is that there was not control for their actions, and on the one hand, and on the other, that there was a lot of pressure over them to show results, and it was the reason why they began to do the body counting. As a result of these facts, Colombia has been involved in an international debate about if the phenomenon of body counting could be considered a crime against humanity, because it was very big. So if we can find proof that it was widespread and systematic attack against peasants and poor people, maybe it could be considered as a crime against humanity. And but having in mind that possible problem, former President Uribe and also our current President Juan Manuel Santos, that used to be the defense minister, defended the idea that it was not a state policy, that it was only certain cases that we had in different places of the country, but not a general policy. However, there are some victims or victim relatives and also civil society organizations that are seeking to bring the case to the Inter-American Court. Anyway, we will have to see what happens, because it takes too long to have a case there. In the meanwhile, we have had a significant portion of low-rank soldiers that have been taken to jail because of those crimes, but only a few high-rank military that have gone to jail for the same crimes. It is true that the government tried to do something to solve, in some part at least, the situation, and for that they retired 27 militaries from the army, but they never explained what was the procedure that they follow, or what were the proof that they found to decide that only those 27 militaries and no more were the ones responsible for the body counting that we had some years ago. So that's the story about the problem that we have with body counting. But now we are having a discussion that is related to that problem, because the Congress is discussing if we pass a constitutional reform that will make broader the military justice. Basically, the rule that we have law regarding military justice is that crimes committed by militaries will be judged by military justice only if those cases are related to their service, to the work that they have as militaries. But if it is something completely different, it won't be judged by the civil system as the other crimes committed by the rest of people. It follows the international jurisprudence, also the jurisprudence of the Inter-American system, and also the jurisprudence of the Constitutional Court, the Colombian Constitutional Court. But the proposal that we are studying now is that some people, especially the militaries and also the government, want to make broader the military jurisprudence, military justice, changing the rule. Now the rule would be that cases would go to the military justice in all cases, except if it is a case of genocide, crimes against humanity, or disappearances. All the rest of the cases would go to the military justice. What's the problem with that? The problem is that we would have many cases like the body counting that I just explained, and some other cases like sexual violence that are not related with the work that the military has to do as militaries, that would be judged by military judges. The military and also the government has different reasons to argue that change is needed. But I think that the two reasons that they present are not very strong, or are very weak, in fact. The first reason that they present is that they said that the army feel that civilian justice could prosecute them based on any action on the battlefield, and that prevents them from acting forcefully against guerrilla. And the second reason is that they believe that only a military judge will have the knowledge enough to judge the action that they do in the battlefield. However, both arguments can be answered, because on the one hand, official statistics show that it's not true that the military have been criminally prosecuted by the civil justice for all the cases in which they are working. They have been prosecuted for the civil justice only in cases related to body counting or extrajudicial executions. It is easy to know that, because if you can study or can read the official statistics, it is clear that there was a period in which there was a lot of cases in the civil justice in which were involved militaries. But those cases appeared in the civil justice only in the period in which there was the increase in body counting. The rest of the year, before and after that period, there are not many cases of military agents being judged by the civil justice. And the second reason is that it is also a weak argument to say that the activities done in the battlefield is too specific to be judged for a regular judge. Because if it would be true, so we would have to have doctors judging things related to medical liability, or a specific judge for any kind of problems that we can have in different activities. But we don't have it because of two reasons. Firstly, because yes, we can have judges specialized in certain areas, even if they are not, I don't know, a doctor or any other profession. But the other reason is that judges can work based on the help that they can have from different professionals that have the specific knowledge that they need. So basically the idea is that the arguments that are being presented by the government and also by the militaries in Colombia to change the rule that we already have regarding the military justice are too weak, but are very risky for in terms of human rights, because if we allowed that constitutional reform to be done, so cases like I think that the most worrying cases would be the false positive or body counting, and also sexual violence, that are two cases that are very common in Colombia in the context of the intern conflict that we have. So I think that there's not a lot of to be done inside of Colombia, because this initiative is being supported by the government and the army, that both are very powerful actors. But I think that there is a big hope in the action of the international actors that could highlight that it could be very problematic for us to make that reform. Thank you.